Good evening and welcome to the third installment of Northstar's 2025-2026 Family Education Nights. It is my pleasure to introduce Matt Bellinger from BeneCounsel. Matt has been speaking with us for, this is his 12th year that he's been presenting information to Northstar families and to the broader public with information about independent living, specifically power of attorneys, guardianships, disability benefits, and special needs trusts, and all other things that have to do with legal decision making. My name is Holly Peel, and I'm the director of Northstar Career Center. Northstar Career Center works with high school students and young adults to empower them as they prepare for the workforce by fostering independence, confidence, and self-advocacy. Our 5 vocational areas, including business technology, materials handling, construction, hospitality, veterinary assisting, prepare skilled employees for targeted growth sectors of the Central Virginia labor market. Without further ado, I will direct you to the chat where I will put my contact information. Also, I'm going to drop a link to some notes from this evening that Mr. Bellinger has very graciously prepared for everyone to access. And finally, the PowerPoint will be emailed out to all participants probably tomorrow following this evening's event. Thank you so much, and we're looking forward to your presentation, Mr. Bellinger.
Great. Thanks for having me. So I'm Matt Bellinger. I'm an attorney with BeneCounsel. It's a law firm I started about 12 years ago. My daughter's on the autism spectrum. I was trying to figure out Medicaid waiver services for her and getting confused. And I'm an attorney, and I threw my pen down and thought to myself, you'd have to quit your job and do this full time to figure it out. Not just Medicaid, but all of the different benefits and everything. So that's when the light bulb went off, and it took me a while to retool to do this, but this is what we focus on at BeneCounsel, is working with young adults and disabilities and their families. And my daughter went to Northstar Northstar School and also the Career Academy, and it was a wonderful opportunity for her. Completely changed the course of her life at that time frame. And now recently she's a VCU ACIT in college graduate, and just passed her learner's permit test and is starting to live independently. So Northstar played a very critical role in that. Anyway, so what we'll be talking about tonight is the kind of things that you'll need to think about when your son or daughter is turning 18. Let's start with capacity, powers of attorney or guardianships, talk a little bit about disability benefits, and then at the end we'll touch a little bit on special needs trust, a way to protect disability benefits and leave an inheritance for your son or daughter's benefits without messing up their disability benefits. So when a person turns 18, they're presumed, well, they have the capacity to make their own decisions, or they're presumed to have that capacity. They're an adult. It gets harder for parents to do things for our children. And there's a bunch of privacy laws that snap into place. And like I said, children who turn 18, when they turn 18, are presumed to have the capacity to make their own decisions, even if they can't or even if they need help. And we'll talk about the ways that we can help parents help their kids at that moment in time. Basically, medical powers of attorney or powers of attorney in general, or guardianship, and that's when we'll get into that discussion. They typically become eligible for disability benefits at that time. Up until they turn 18, parental income and parents' assets are deemed to be the child's, but once the young man or woman turns 18, it's just their income and just their assets. So we'll talk about that. I start with this slide, definition of incapacitated person. It's somebody that can't process information well enough to be able to make informed decisions for themselves, especially when it impacts their health care or their safety or their therapeutic needs, or on the financial side, well, you know, it impacts their financial ability to manage their own finances. And it goes on to say that poor judgment alone isn't sufficient evidence. That's more applicable, in my opinion. That particular part is for elderly persons if they start making poor judgment. Anyway, it's part of what the Virginia Code uh, has for the definition of incapacitated. But like I said, for this conversation, we're really talking about somebody's ability to process information in order to make decisions. We'll start with alternatives to guardianship because these are the least restrictive and the easiest and ways to help young man or woman make decisions. So powers of attorney. There's a durable general power of attorney. There's a medical power of attorney, or in this case, it's called, this slide is called an advanced directive for healthcare. And there's a power of attorney for education. There's 3 documents that some young men and women have the capacity to sign when they turn 18. And the legal capacity to sign a power of attorney is that person signing it needs to understand the authority that they're giving to their agents. They don't have to necessarily be able to read the document or have a long drawn out discussion with me about agency relationships. Just have to know that when signing it, they're allowing mom and dad to continue to make medical appointments and fill prescriptions and do these things for them on their behalf. Um, and since I work solely with young adults with disabilities, I like to find that level of capacity whenever possible. And when we're talking about powers of attorney, and the reason I like to find that capacity is if they will work for a young man or woman, these don't take away any rights. They retain the rights to make their own decisions and do things for themselves. With powers of attorney, they're appointing agents, usually their parents, to work on their behalf. Um, and I see that capacity determination as a sliding level of capacity. A power of attorney that a young man or woman is signing to allow their parents to make medical appointments and fill prescriptions like the medical power of attorney, that's a pretty fairly low capacity required. It's not like a power of attorney that, Elon Musk likely signed that allowed his attorney agents to negotiate the purchase of Twitter, right? There's likely a power of attorney involved there that gives the agent some ability to negotiate that so that's a much higher capacity, right? Uh, you got to really know what's in that document and what you're giving your agent. Whereas opposed to medical power of attorney for a young man or woman with disabilities, I think that it's very straightforward. And in fact, I think that when I'm having that conversation with most of my ultimate clients, the young men and women with disabilities, I don't really think they think it's a silly question. It's like, what the heck are you talking about, Mr. Attorney? That doesn't make sense. Of course, I want my mom and dad to do these things. That's what parents are for. I can almost see it in their eyes, and it always gives me a little bit of an internal chuckle. But so 3 powers of attorney, a durable general power of attorney. It's for finances, contracts, um, Medicaid applications and forms, working with the community service board for waiver services, anything of a contractual or financial um, in the financial realm. A medical power of attorney allows you to make medical appointments and fill prescriptions. Doctors talk to you because it has a HIPAA release, and you can help your son or daughter make medical decisions. And then there's also a power of attorney for education, which is for IEP meetings. And you can sign off on the IEP. Your son or daughter can also, but if they don't want to, they usually, most of my clients, they go to the meetings, but they don't necessarily finish in the meetings. They'll get bored and they want to go back to class or go to do whatever their classmates are doing. And well, with a power of attorney for education, the parent in the meeting can sign off on the IEP. And on the financial side, there's also a representative payee program for the Social Security Administration. You'll see that a couple times in this presentation as an alternative to actually doing a conservatorship. And we'll talk about that in a second. But the representative payee program is Social Security Administration. When a beneficiary can't manage their own finances, the Social Security Administration then appoints a representative payee to manage those finances for them. And as representative payee, then you'd have control over their disability benefit, manage that. So we're talking about powers of attorney. I start there when I'm working with clients and see if their son or daughter has the capacity to sign them. Sometimes, uncertain as to that level of capacity, but also there are other things. Just because I think that the power of attorney that the young man or woman may have the capacity to sign, it doesn't mean we stop there and automatically just do that. There are certain situations where I tend to start thinking about guardianship. One is severe mental health challenges, schizophrenia, bipolar disorder. Um, because although a medical power of attorney can have some special powers and it allows the agent to get inpatient mental health treatment for the person, even against their will for a short period of time, that works getting them in for the treatment. But in a couple of cases last year, what didn't work was the follow on after 3 or 4 days of receiving inpatient mental health treatment and the facility is ready to discharge. The power of attorney doesn't give the parents the authority to override that, to say no, to make the decision, whereas in a guardianship you do. So mental health issues, um, powers of attorney could still work, but much longer discussion needs to be had. And same thing with some severe medical challenges. If somebody needs surgeries or heart surgeries and things like that, sometimes it's if we're on the cusp of deciding whether or not it's a power of attorney or guardianship is best for the young man or woman, sometimes we'll go with the guardianship route. I had one young um, client, Down syndrome, had several heart surgeries, um, and she had been talking about not wanting to go back to the hospital. We did guardianship because parents really didn't want to have any question as to who gets to make the decision if she had to go back. Um, so guardianship. That's the other alternative. There's really only two alternatives. I only have two tools in the legal toolbox as powers of attorney and guardianship to help at that point in time. Guardianship is a process in the local circuit court, local to you. You file a petition asking the judge to appoint a guardian or co-guardian, so more than one person can be guardian at the same time. You can also ask the judge to appoint a standby guardian, which is somebody that basically it's a successor, does nothing while the guardians are living, but then would step into their shoes and be able to make decisions for the ward after if something happened to the guardians. As part of the process, the judge appoints another attorney, and that is a guardian ad litem that represents the young man or woman's best interests, not their attorney, but to represent their best interest, to be a neutral third party, to meet with everyone, meet the parents, meet the child, um, look at the medical reports, and then report back to the judge in writing. Does the person need a guardian? Are the proposed guardians suitable? And would less restrictive alternatives work, like powers of attorney instead? And in cases where it's parents for an adult child with lifelong disabilities, that it's really straightforward. So as a side note here, I'm going to use parents and child, but it also could be grandparents for a grandchild, or it could be adoptive parent, or, so it could be sometimes do guardianships and it's sisters for their sister. So it doesn't have to be parents, but I'm going to continue with that just because it's, well, it's easier for me. Do it that way. So in a guardianship case, though, the person loses rights. They lose the right to make their own medical decisions. They lose the right to make their own educational decisions, um, decisions about where to live. They also typically lose the right to drive and the right to vote, although sometimes I can get a court to allow a young man or woman to retain those rights. Courts are usually very pessimistic about, not pessimistic, it's the right word, reluctant to allow the right to drive if the person's not ready yet, because you can go back and restore rights. And I've done that a few times too, where you go back to court and ask the judge to restore a young man or woman's right to drive. That typically is, 4 or 5 years after the initial guardianship. They've passed the learner's permit test. They may be scheduled to go to WWRC for the driving course, and they just need to have the ability to get a learner's permit. Judges sign those orders easy. Right to vote is getting more difficult to have to get a judge to allow a young man or woman to retain. Part of it's political climate. Part of it also, unfortunately, is an unintended side effect, I think. The General Assembly has been making changes to the Virginia Code last several years to put more checks and balances, and I think they're on the right track and that they're doing good things. But one of the recent changes 2 years ago, I think, is that the guardian litem has to report to the judge in writing why powers of attorney won't work. Well, I'm having a harder time making a good argument as to if I don't think powers of attorney would work, right? If I don't think that my client has the capacity to appoint an agent to act on their behalf, how is it that they have the capacity to elect an agent on their behalf? Now, one's protected, is a, you know, constitutional right. So anyway, some challenges there. So, but typically they'll lose the right to drive, the right to vote, also the right to marry without the guardian's permission, the right to sign contracts, the right to possess a firearm, the right to execute wills and things like that. So it's restrictive. Are such things as limited guardianships. Talk about it in the Virginia Code. I have not done one. I might have my first. It's really challenging, not challenging. I would say it's impossible to write a guardianship order that gives some decision-making rights to the guardian and retain some decision-making rights for the person. For example, medical. What do? You put it as they make their easy medical decisions and the guardian makes the more difficult ones or makes it about this, then you're leaving it up to the doctor. And that's power of attorney realm. That's better for that. So limited guardianships are are tough to figure out how to make that work. Um, so guardians make personal decisions, medical decisions, decisions about where to live, what are they going to do during the day, but not financial. Financial decisions are made by a conservator in Virginia. It's the same process as a guardianship. Um, one is over, personal decisions. The other is over financial decisions. It's like flip sides of a coin. Um, but for the most part, I don't do conservatorships because most of my ultimate clients, young men, women with disabilities, don't need a conservator. They don't have any finances. They've not been working their entire life. They don't have an estate to manage by a conservator. Um, the Social Security Administration doesn't use conservatorships. They use the representative payee program. So you could have a representative payee managing your disability benefit and a conservator managing everything else. But again, for a young man or woman, there is no everything else typically. Sometimes, though, a young man or woman under guardianship can work, and their work, their earned income. In those cases, I recommend that they direct deposit it into an ABLE account. That does two things. One is money in an ABLE account doesn't count as a resource for SSI and Medicaid, and we'll go into that a little bit more. There's a further slide. So right then off the bat, their earned income isn't going to affect their disability benefit eligibility for accountable resources. And you can have a parent on there as well. So, and you get them one of the debit cards off of that, and they can have some limits on it. So it's managed without a conservator. And conservatorships can come with reporting to the commissioner of accounts. It's like being an endless probate with initial inventory and then annual accountings. And those, some commissioners will waive that. Um, some can make it every 3 years. The fees are less for persons under Medicaid, but why add in forms and fees if you don't have to? So the times I do it is when somebody gets a direct inheritance or an injury settlement from, a lawsuit. And then we need somebody with the legal authority to manage their finances, to take that money, put it into a particular kind of a special needs trust to make sure they maintain eligibility for SSI and Medicaid. And then we typically end the conservatorship after. So guardianship, conservatorship, it's a court process, circuit court. Takes about 4 months for me to get a guardianship in place. The earliest you can file a guardianship petition is 6 months prior to a person's birthday, 18th birthday. So 17 and a half. So when your son or daughter's turning 17, that's a good time to start talking to somebody, even 17 and a half. But there's actually no difference in the process whether you start it before or after they turn 18. In fact, the what we're talking about here is adult guardianships and conservatorships. It's the same if we were talking about parents with dementia. We had to do a guardianship or conservatorship for them. Same process. Um, and what I've found is from just practical reasons that once you start the process, even if the hearing is after your son or daughter's 18th birthday, um, all the parties that you would need guardianship for to show them that you have legal authority to make decisions for your son or daughter, they treat you as the guardian already and just say, give me a copy of the order when you get it. In fact, I've got a number of cases, maybe 30 to 40% every year, where the young man or woman's already 19, 20, 21. For various reasons, parents were not able to do guardianship right at 18. So I wouldn't fret that. Best time is to try to get it done on or about their 18th birthday because there's no gaps then. And if you're having anxiety over, they're turning 18, that way you don't have to worry about it. Powers of attorney, start time for those is about the same time to figure out which is the best way to go. Um, we typically write the powers of attorney a month or two before their 18th birthday, send it for review, and then we meet after they turn 18 when they have the legal capacity to sign them. So one more thing that I thought about for powers of attorney that I didn't mention is that signing a power of attorney appoints agents. And those agents, as an agency relationship then with the principal, the person, the young man or woman who signed it, they still can make their own decisions. They can still do things for themselves. It doesn't take away that right. Um, and parents can use those documents as little or as much as they need to. We have them for our daughter. The medical power of attorney is much more useful. We use it more often, quite a bit. My daughter can make her own medical decisions. She can make her own medical appointments. She can fill prescriptions. Um, but lining up a new doctor, she usually asks her mom to do that. Or sometimes for an appointment, if it's something that she doesn't want to talk about, she's maybe embarrassed about, mom does it. So they work for those. And in the beginning, gosh, it was 10 years ago when I wrote this, 12 years ago. We use them all the time. The durable general power of attorney, we don't really use at all. All the things that we can do with it without our daughter being there. Um, like even signing a lease agreement. I could sign a lease agreement for her as her agent under a power of attorney, but I would never think of doing that. I want her to be there. I want her to sign it. I want her to do it. So they're useful. They absolutely are. But the medical power of attorney is much more useful. But one of the things with the agency relationship is that you can't override decisions that your son or daughter may make if they set their foot down. You can't, say, hey, you signed this power of attorney. I get to make the final decision. No, actually, they still make the final decisions. That doesn't mean we can't use all of our skills that we've learned as parents to get our kids to do what we'd like them to do, like continuing to talk to them to, show them the pros and cons of the particular decision. Um, and even bribery, like, well, you get this shot, then we'll go ahead and go get your favorite um, lunch, right? We'll go to Sonic. Um, and I say shots because that's one thing. That's one of the questions I ask parents about their young man or woman, their son or daughter, about the young man or woman that we're talking about, is well do they do with shots and blood draws? Um, and for some young men and women, that can be a very challenging thing to do. Um, if they've outgrown it, or, oh, yeah, we used to have problems like that, but now they do pretty well, then I'm thinking more powers of attorney. But if they come back and say, oh, no, absolutely not, when we have to get a blood draw to check for liver enzyme levels, we basically have to physically restrain them a little bit. And then I'm thinking guardianship, only because since a power of attorney doesn't take away their rights to make the decisions, they're actually through their actions and maybe even know if the words saying they don't want it. And that's their decision, even if the doctor or even if the parents both agree that they need this blood draw, they're not going to get it. Whereas with the guardian, if they have a power of attorney, um, and that's kind of circles back all the way around to the definition of incapacity. At that moment in time, refusing a blood draw, even though they absolutely need it, kind of tells me that they're not really processing information very well, or at least the consequences of not getting their blood draw at that moment. So that's start leaning more towards guardianship at that point. Another deciding factor often is how verbal they are. It is absolutely possible for a nonverbal person to sign a power of attorney, but they have to be able to communicate with me in some fashion, their understanding of that agency authority. And if they use a device, then absolutely. So that's, I've done it a few times for nonverbal persons, and it's always they were able to communicate with the device. Um, but when a person's minimally verbal and they don't communicate with a device or in some other fashion, typically then guardianship is the way, at least my advice to go. So a little more about guardianship. Recent changes to the Virginia Code. Like I said, the General Assembly's been doing that. This last year, they didn't make too many, so maybe they'll have slowed down a little bit. But every year, that was having to change forms and change processes and do it. And I think it's all a good thing. They're all trying to get it to the point where there's more checks and balances because from the General Assembly standpoint, and I absolutely understand it, they're enabling a state actor, a judge on behalf of the state to take away a citizen's rights and give them to another person. And they want to make sure that that's being done in the appropriate situations, that if that it's not a last resort, but it is almost like a last resort, and that they're doing it with enough checks and balances. So one of them they've added recently, and I'll say recently, last 2 or 3 years, was that judges are supposed to set a series of review hearings. And the first one being a year later, and then it can be every 3 years later. For most of my cases, when it's parents for an adult child with lifelong disability, judges waive those review hearings. It doesn't make a whole lot of sense, but sometimes we have them still. Um, Used to be the standard for visitation was that guardians can't unreasonably restrict visitation with somebody. Didn't really say what's unreasonable. Now there's a process to do that. There's forms to use and notifications to the court and to the person. So if they want to challenge it, they can. I haven't run into any cases like this for restricting visitation, but there's a process now for that. Required visitation. Most parents, all parents, when I talk to them about this, they're like that, okay, that why do they have to tell me how many times I have to visit my child? Because they live with me, or I see them all the time, even if they're in the group home. Um, but it used to just say the guardian had to visit enough times as reasonable to be able to understand basically what the needs of the person was. And um, I think this particular required visitation is more towards like attorneys that may be guardians for persons or, more private guardians. Um, because like I said, for parents, they visit their kids all the time, but it's at least once every 120 days, once in person. And the other two can be through like a surrogate or through, Zoom or over the phone. So, um, and starting this year, guardians have to do mandatory training. One of it's an hour-long online course. Department of Aging Rehabilitative Services. The clients that have provided feedback to me said parents of children with disabilities aren't really going to learn much because you've been making decisions for a person their entire life. But like I said, not everybody is a parent. These adult guardianship cases run the gamut of ages for the person and for the relationships to them. Should go on. I was talking about these are recent changes, but they're also a little bit talking about responsibilities of a guardian. And one thing I've been trying to make sure the guardians understand is in addition to the training, they have another responsibility once they're appointed as guardians, and that there's an annual report. It goes to social services. It is first one covers the first 6 month period, so it's filed first 4 month period and filed within 6 months, and then it's annual ever after that. And the reason I'm trying to emphasize that more, um, with all these changes to the Virginia Code, the Virginia Supreme Court training to judges has also emphasized things, and that report is getting much more emphasized. Not so much what people are putting on the report, but whether or not they're doing them, because clerks are supposed to submit to the circuit court judges a list of anybody who's 90 days overdue with their report, and many of them have not been doing that. I'm starting to see more emphasis with that. Um, and that would be one way for a judge to say, "Hey, guardian, come here, let's talk. Tell me, well, there's a bond you signed. I'll talk about that in a second. Yeah, and why didn't you do your report?" And so far, I've had it happen a couple times. We cure it. We submit the report, and then they don't have to go talk to the judge. Um, but that's going to get added, I think, added emphasis in the next several years with that. So I mentioned a bond. So guardians sign for a guardian's bond. It's $1,000. It's unsecured, so there's no payment that's made on the bond. It's basically a paper promise to the judge to continue making decisions for the person's best interest. Um, what it works as in a guardianship case is for jurisdiction. Judges have supervisory authority over guardians. Um, when a case is closed, they have no way to basically to enforce their authority without that bond. With the bond, they can say, "Hey, guardian, come here, let's talk. Tell me why I shouldn't fine you that bond." So it's a jurisdictional hook. In a conservatorship case, when we're talking about money, that bond is much more significant. If the person had, say, for example, half a million, $500,000 estate, the bond will be set for at least $500,000, and there's insurance on the bond. So a bonding agent has to go to the probate appointment, and you have to pay for that insurance every year. And then insurance basically indemnifies the person if the conservator does wrong, and then the bonding agent goes after the conservator, try to recover that money. So another reason to avoid conservatorships, bond and anyway. All right, well, yeah, I did talk about that. So the annual report goes to social services, a $5 filing fee. Judges do read them. Um, Guardians are not liable for acts that the person may commit, um, unless they're negligent. There is no case law, but on that, my example is if I were guardian for a person and I took them to Target and there was episode where they maybe knocked over shelves and threw something, um, I'm not negligent. That's not a problem. I'm not liable for that. Go the second time, probably not. Yeah, but by the third or fourth time that happened, then yeah, maybe I'm negligent. I should not be bringing them to the store where something is obviously triggering them, and that's on me. Um, Guardians are not required to expend personal funds on behalf of the incapacitated person. They don't have to live with them. They don't have to provide direct care. Guardians' primary job is to make decisions for the person. And I bring that up in that tone of voice because if you're thinking of guardianship and you're starting to talk to potential standby guardians, I think it's important for them to understand that they don't have to be the one providing direct care because that can be a very daunting task. I think it's up to us as parents to get that all set up in place. Where is our son or daughter going to live long term? Who's going to be providing that care? And waiver services might have attendants coming in and things like that. So anyway, guardians don't have to do that. There's a process to change um, states. If you move to another state to transfer a guardianship from one state to another, most states follow some version of the model rules that limit jurisdiction to the state where you're living or where you've got a guardianship already. That's really so that you can prevent forum shopping or conflicts between states. So My dad lives in Mississippi. If my sister was trying to get a guardianship from there and I decided, oh, heck no, and I went and picked them up for the weekend and brought them back to Virginia and started it here, yeah, that doesn't work. It's, where a person's living. There's some really specific jurisdictional rules. So once a state court has appointed a guardian, that court has jurisdiction and you can transfer that to another state. Um, Now, guardianship doesn't have to be permanent, though. You can restore all of a person's rights and terminate the guardianship. I did that for one young woman in Danville. I met her. She was 28. She'd been under a guardianship for 10 years. She and her guardian had had a falling out. She had not seen her guardian in a number of years and was making her own medical appointments. She was filling her own prescriptions, making her own dental appointments. She was getting to and from work through the PACE or PAVE, Medicaid sponsored or paid for transportation. I said she's working part-time. She was doing all of the things that you would expect a person to do if they didn't need a guardian. And we put on about 2 hours of evidence for the judge to hear. Um, and I know I could tell the judge wanted to approve it, worried though that are we just cutting her loose, right, without any support network. So I had to put on evidence that, oh no, that's still case managers. And oh, by the way, her grandmother's here and we're going to sign powers of attorney. We're going to have an agent be able to work on her behalf. So yes, you can restore rights. And the opposite is true too. When I'm talking with parents and we're talking about powers of attorney, sometimes it's a little worrisome for them about how that's going to work for their child at 18. And so if you do start, and I suggest if it's a possibility to start with powers of attorney, if you do that route and you run into problems that are insurmountable, that we can't work around and they're significant, then you can do a guardianship. And at that point, it doesn't necessarily make it easier, but it makes it more straightforward. And we say, hey, judge, hey, guardian ad litem, we tried powers of attorney. Here they are. And this is the problem we ran into. This is why we need guardianship. Um, and like I said, the only times I've ever had to do that, though, for mental health issues. Because the thing is, our children at 18 don't stop learning. They don't stop maturing. They continue to do that at their own pace. So if we think powers of attorney work at 18, well, then 23, 27, they just work better because your son or daughter will continue to develop at their own pace. So do you want to do questions now? Or I guess we could save these to the end.
I
Sorry,
have a
Holly.
couple questions that I'd love for you to do now.
All right. Yes, let's do questions now.
And this one I probably should have asked you before, so I'm gonna put you on the spot. I apologize. I only recently learned about Ulysses clauses in advanced medical directives for folks who have mental health situations or any situation where they may want to have an advanced medical directive that includes instructions to a doctor that says, hey, right now I'm of sound mind and body, and this is what I want out of my health care. And then if they were hospitalized, including for mental health reasons, and said, I don't want to stay here, the doctor can use that advanced medical directive to make
Oh yeah,
treatment decisions.
yeah.
Do you have experience with that? And can you speak about that at greater length? Because it seemed like a way to not necessarily have to use guardianship as an option.
Yes. So that's the special powers and a medical power of attorney that I was talking about.
Okay.
Um, and the doctor and the agent can absolutely treat the young man or woman, or it doesn't have to be young man or woman. I have that in my advanced directive. Um, can treat the person against their will even for a short period of time, up to 10 days. The situation last year with the two clients was that they did that about 4 days or so of treatment, and their sons were both sons in those cases starting to gain capacity. facility called, said, hey, they don't meet the criteria anymore. We're going to discharge. Parents are like, oh no, we're not ready yet. He's not ready yet. We're trying to, working with his a psychiatrist for follow-on supports. We need more, but they couldn't stop it. And one was okay-ish. The other had a same exact thing happen. And it had to go back, right? But it's the going back. If it were just an issue of getting them back in for mental health treatment, that's not so bad. But the way that happens in Virginia is typically through the police. And um, that's not always, nothing bad about the police, but it's easy for a young person in crisis with having a mental health break to injure a police officer, and they can be good about it, but the second time, they that in that case they weren't so forgiving, and so then there's criminal challenges. So that's why I really, we talk about them, I have them, I think about it, but I like guardianship a little better because how does a guardianship change that? Guardianship changes it. So when the hospital says, hey, we don't meet the criteria anymore, we want to discharge, the guardians say, yeah, no, I make the decisions. I'm the guardian. So let's set up something where they can go to. Yes, we agree. You want to discharge from your particular facility, but we're lining up some more follow-on care here. They need a little bit more time. So that's how a guardianship works. Better, differently in that situation.
That's very helpful. Thank you. Yeah, I appreciate your description. I don't know that any of us want, including police officers, want police officers to become healthcare providers.
No.
Sometimes that's how that situation goes down. So we appreciate their service and also
Well,
look
there is
at
a law
creative
that
ways.
says that communities can use alternatives for transport in those
Sure.
situations, but most aren't doing it. I don't, it's funding, I haven't looked into it, but really should be a social worker, in my opinion, that has the time and the energy to talk to somebody that needs mental health care to go get that mental health care.
Right.
Not a police officer. They're trained differently.
Yeah, and there's a variety of reasons, depending on the locality. Yeah, we could speak about that at greater length, but we won't address it
That's not
here.
the
It's
topic of
certainly,
our,
yeah, it's
right?
there's a lot of things going on that can speak to that situation. And the other, I would just add to the training that DARS offers for guardians. I went through it myself, so I appreciate the content that came together. That and some of the other guidelines you were talking about can be very useful in situations where siblings might be taking over some of those guardianship roles. And we see that quite a bit. Maybe parents are aging or parents are going to travel, and siblings who were teenagers at the time a lot of these decisions were being made are now stepping into an adult role, but their experiences as a child sibling of a lot of these big decisions. And so to be able to sort of do a retrospective and do a training and see it through an adult lens has been helpful so that they can start to take those responsibilities over.
Good.
All right, I don't see any other questions at the moment.
Okay. We'll go back. Continue. So 18. Like I said, that's typically where a young man or woman becomes eligible for disability benefits, the ones we're going to talk about here today, or at least SSI. It is possible for a child to receive SSI when parents have low income and low assets. Um, but many cases, it's uh, when they turn 18 because they don't have any income at that time. And as long as they have less than $2,000 in countable resources, then they'll meet the financial requirements for SSI. So we'll talk a little bit about SSI. We'll talk about Social Security Disability Insurance, SSDI, and the Disabled Adult Child Benefit, a little bit about Medicare and Medicaid. I wish they had different acronyms, SSI, SSDI. They are two completely different programs, but they share a major similarity. So SSI is supplemental security income. It's for persons with disability or blindness or over the age of 65 that have low income and low assets. Um, The asset limit is $2,000. So you have to have less than $2,000 in countable resources, which basically means anything in like bank accounts and um, some other things like even life insurance counts as a countable resource. The home you live in doesn't. Um, so that's not a countable resource. You can own one vehicle that you use that's used for your benefit. That doesn't count. Tangible personal property, like furniture and clothes, that doesn't count as a resource. It's looking at cash and cash-like things. There is an income limit, and so when I say income limit, it's a little different depending on whether you're working or not. There's work incentives that can reduce effective earned income. But basically, what we're talking about here is built into the definition of disabled is whether or not somebody, for SSI purposes, for Social Security Administration purposes, can perform substantial gainful activity. So a person that's going to receive disability benefits cannot perform substantial gainful activity. And that doesn't mean they can't work at all. That means they can't perform substantial gainful activity. I said it 3 times now. It's a defined term, SGA. And SGA, one definition of that is whether or not they make more than $1,620 a month. That's in 2025. I think that number changes for next year. I don't have that written down yet. So if you make more than $1,620 a month, you're not disabled, no matter how disabled you may be. But our young, our children, when they're turning 18, aren't working, so they meet that income limit. Um, the maximum benefit is $967 a month in 2025. That also goes up. It's not a whole lot, but it's meant to help pay for room and board and food. Um, Probably heard that you want to charge rent for a person who's getting SSI if they're living in your home, and that's because SSI is saddled with a whole bunch of stupid little rules. One of them is since it's meant to pay for living arrangements, if they're living in your house and not paying their fair share, there's a 1/3 reduction that kicks in. The Social Security Administration starts all new recipients with that 1/3 reduction in place. And so instead of getting 967, you get like 650. Well, the way to get the full benefit is to charge them rent. We'll call it rent. It's not rent because you're not in the business of renting out your house. What you're doing is you're actually charging their fair share of actual expenses. So add up your mortgage or rent for the month, gas, electric, water, sewer, if you're paying for those for the month, divide by the number of people living in your home, and that is your son or daughter's technical fair share. That's what they should be paying to you each month from their SSI benefit to reimburse you for their share of your actual expenses. And you can add food to that. Well, it used to be that if somebody helped an SSI recipient with food, even $1 of food help would cause that 1/3 reduction to kick in. 2 years ago under the Biden administration, they dropped that, and I'm thankful. I mean, the optics of charging somebody, giving them less help if somebody's helping them for the food, that's just ridiculous. But anyway, like I said, SSI, lots of stupid little rules. So if you're charging them their fair share for living arrangements, then they'll get the full benefit. Doing that also not only gets them the full benefit, but it's also the largest monthly drain on that their their income, their account. So as their representative payee, Social Security Administration appoints you as their representative payee. You open an account in your name for their benefit as their representative payee. The Social Security Administration deposits that money in there. The SSI benefit each month. You pay yourself for the room and board, and that leaves maybe $150 every month that you spend on their benefit to pay for medical co-pays, food, not food, food, if they need it, clothing, books, whatever your son or daughter needs. Because that representative payee account also counts against the $2,000 countable resource limit. So charging them for their fair share of living arrangements keeps that account under $2,000. And it, in a way, it kind of washes the Medicaid payback and Medicaid stink off of it. Any money that a SSI recipient or Medicaid recipient specifically has when they pass is subject technically to Medicaid estate recovery, go back to this state. But when you're getting paid from your son or daughter's SSI for their living arrangements, that doesn't carry on. Once it's your money, you do whatever you want with it. Obviously, you're going to use it to support your son or daughter, but no longer has any Medicaid implications to it. Um, Earned income. So when your son or daughter, if they're capable, and since we're talking through Northstar Career Academy, many of the participants here today, their sons or daughters likely will be able to work. But earned income will reduce SSI, but it's not on a dollar for dollar basis. There's work incentives. The first $20, there's a general income exclusion. There's a $65 earned income exclusion. There could be other work incentives that apply, but at that point, the Social Security Administration takes those deductions, divides then the remainder by half, and that's how much SSI the person loses. So the takeaway for this is that you'll always earn more money working even though your SSI is reduced. Um, Social Security Disability Insurance, similar acronym, but different benefit. It's a Social Security benefit now. SSI is not. It's part of our general safety net. It's paid through by the general federal budget, much more at the whim of our politicians. SSDI is Social Security benefit. It also has, our politicians can mess with it, but they have to do so in a way that doesn't tick off all of the Social Security recipients, the AARP, right? So it's harder for them to change these rules. And it doesn't have stupid little rules like the 1/3 reduction and things like that. But anyways, SSDI is for workers that have been working and getting work credits and paying payroll taxes. If you become unable to perform substantial gainful activity, it's the same definition as SSI. Then you can draw a disability benefit off of your work record. Now, the amount of work credits that you need to qualify for SSDI depends on how old you are and how long you've been working. I've been working long enough and I'm old enough now. I think I'd need 40 credits. You can get 4 credits in a year. I need to have 10 years of work in a specific time frame and meet the medical requirements for SSDI. But the work credits are much more for me. But for a young employee just starting out, they can get enough work credits in maybe 3, 4 years, to be able to get SSDI off of their own work record. Starts out small, and for SSI, stupid little rule, it reduces their SSI on a dollar for dollar basis. So if they're getting $300 of SSDI, the SSI is reduced by 300. So they don't get any more benefit, but the more they work, the larger the SSDI goes. And SSDI comes with Medicare after 2 years. So that's a good place to be. So working for a young man or woman, even though it reduces their SSI, they get more money and they can eventually qualify for SSDI and Medicare off of their own work record. And then there's the disabled adult child benefit. This is a Social Security benefit. Used to be known as a childhood disability benefit, but whenever you Google that, you look at it, it would just bring up child benefits. And that's not what this is. This is for adult children disabled before the age of 22, um, that's unmarried still. When a parent retires and starts drawing Social Security or becomes disabled and starts drawing SSDI on their own work record, or when the parent passes, the adult child who is deemed disabled before the age of 22 can draw disability benefit off of the parent's work record. And that can be substantially higher. It depends on the the parent's work record. But I have clients who get $1,400 to $1,800 a month um, while the parent's still living. And then I have some clients, the parents passed, and it can be like $2,400 a month. So it's substantial. Now they don't get SSI anymore. It wipes the SSI out, dollar for dollar reduction, but this also comes with Medicare. Um, and for those that, and they're all these clients, if you're getting these disability benefits, they have usually Medicaid waiver services too. So you keep those and you can be dual eligible for Medicare and Medicaid. But the disabled adult child benefit is something to know about. Not so much so that you can time your retirement, but so that you know that the benefits that your son or daughter may be eligible for later on in life are much more substantial than perhaps what they can get at 18. So I've got a graph here, a chart that kind of shows how that looks. SSI only, SSI and part-time work, always going to make more money working even though your SSI is reduced. This is when the child starts drawing a little SSDI off of their own work record. And of course, this is later on when they're drawing the disabled adult child benefit off of a parent's work record um, and their part-time work. Now, there are many young men and women who aren't going to be able to work, so they'll still get SSI, right? And then when a parent retires, they'll get this disabled adult child benefit. I'm not going to do questions here because I want to go quickly on to Medicaid and Medicare. Just touch on them briefly. Um, Medicaid is a joint federal and state program. It's kind of the companion to SSI. It's for persons with a disability or blindness or over the age of 65 that have low income and low assets. The number that's similar across all these benefits that are means tested is the $2,000 countable resource limit. And the income limits vary. So Medicaid has a little bit looser income limit than SSI. And it really depends on the person's situation and what's going on. Um, it's always the payer of last resort. I've got that on here. What I mean by that is that um, personal insurance is always first. So if your son or daughter, you can carry them on your work. If you get insurance through your work, you can carry them on that insurance to 26 by law. I've been pleasantly surprised at how many insurers allow a parent to continue carrying a child with a disability past the age of 26. So when they're getting close to that time frame, if you need them to continue to stay on that, check with HR. Look at your policy, see what you need to do. Sometimes it's as simple as a letter from a doctor saying they have a disability. Um, and so that's always first. If they have Medicare, that's second. If they have TRICARE, which is a military medical benefit, that's third. And then Medicaid is always last. Medicaid. So, excuse me. Medicaid will always pay medical bills last if there's other insurance. Um, but Medicaid also pays for things that other insurance doesn't. So Medicaid also can pay for modifications to a home, like a ramp, for durable medical equipment. So Medicaid is also important. Um, and Medicare is the companion for like SSDI for retirement, for disabled adult child benefit. It comes with those. This is the same Medicare that when we're 65, we become eligible for. And um, that most people rely on. It's much better insurance than Medicaid. Excuse me. Reached the point of talking where my throat's now getting a little frog in it. So um, Medicare, though, the way that a young woman, a man or woman with disability can become eligible for it is if they're working and they're able to get SSDI off of their own work record, they'll get Medicare with that, usually after 2 years, or the disabled adult child benefit, Medicare. And then there are actual programs now, um, plans for the what we call dual eligible people, Medicare and Medicaid eligibility, both, and that synergize some of the benefits from both. Now, I don't do that kind of work, but that's a good time to talk to an insurance agent that does and say, hey, these are your policy plans for Medicaid, Medicare and Medicaid. So any questions about disability benefits before we get into special needs trust real quick?
I just want to remind everybody that requesting a benefits advisor when you start working with the Department of Aging and Rehab Services can be a great way to go. That as a person, sometimes WISA is the abbreviation for these services. That's a person who will sit down with you and the young person in your family to look at your specific situation and see how these things apply. So always make sure that you are referred for that service. We always try to do it at Northstar, but everyone else should do it too.
Good advice. So, special needs trust, a third party special needs trust is where we'll start. This is the kind of trust that parents, families will use in order to leave an inheritance for a person's benefit if they're getting means tested benefits. That $2,000 accountable resource limit that we talked about for SSI, for Medicaid, it's also there for Medicaid waiver services. If a person gets a direct inheritance, it kind of messes up their eligibility for a little bit. They can fix that. The fix is a first party special needs trust we'll talk about next, but that's not one we want to actually use because it has a Medicaid estate recovery clause. When you're thinking about money for a person with a disability, there's two piles of money. There's the persons with the disabilities money, and then there's everyone else's money in the entire world. Everyone else's money is where we want to put it in. Anybody who wants to help them goes into a third party special needs trust, but not the person with the disabilities. Because the third party trust has no Medicaid estate recovery clause. Money in a third party trust, well, typically it's unfunded while parents are living. It sits as an empty bucket protecting their son or daughter's eligibility for SSI and Medicaid if something happens to the parents. And it'd be funded after they pass through their wills and beneficiary designations and like life insurance, IRAs, 401ks, investment accounts, checking and savings accounts can have payable on death provisions on them as well. And because while we're living, we'll continue to support our kids as much as they need it. All right. And then from a financial standpoint, the trust takes over after we pass. The money in a trust doesn't count as a resource for them against that $2,000 accountable resource limit because it's not their money. It's the trust. The trust has a separate tax identification number with the IRS. Once it's funded and those invest the money in the trust, the principal is invested and it starts generating income like interest and dividends and capital gains. The trust will file tax returns. The trustee will do that, and it's managed by a trustee. It's a separate legal entity. It's not the child. Now, they're the primary beneficiary. Sole beneficiary has to be used for their benefit, but it's not their money. And that's why the special needs trust doesn't count as a resource. Funding it, parents can fund it while they're living. And when I say fund it, it's basically you go to the bank with the trust agreement and you open an account in the name of the trust. And it could be any bank that you want to work with. You can change banks, you can move around banks. It's like creating a small investment company. It's not a company, but it's a lot like it. It's a trust and it can own anything that a person can own. But when I think through funding it, if I had $10,000, I could put it into my daughter's third party special needs trust. I could use Wells Fargo advisors. I could call my agent and say, hey, I want to buy this stock, and we could do that. But 20 years from now, when the trust sells those stocks, it's going to realize capital gains from the purchase price to the sale price. If, on the other hand, my wife and I take that same $10,000, put it in an account in our name, buy the same stock, but then put a beneficiary designation and it says, hey, when we both pass, put this in our daughter's trust, it'll pass then at the stepped up basis. So I like the idea of parents having their money or family having their money while they're living. And then this is third party trust really for funding after they pass or when we get close, if I don't know, it's hard to tell when we're going to pass, but there comes a certain point where I would want to fund it just to make sure that it's ready, that start paying for a cell phone, start doing things with it so that it's a little bit easier for the people that we leave behind. That's one reason to fund it. Other family members can fund it too. So grandparents, if they want to leave money to their grandchildren, they can do that and leave it to the trust instead. So my parents-in-law did that before they passed. They changed their estate planning because they wanted to leave all their grandkids some money. So my daughter's trust has some money in it now. My wife does the investing, and I do the taxes. It's not that hard. Um, but we haven't used any of the money in it because we're still supporting her. We could. Third-party trusts can own, like I said, anything that a person can own, including real estate. So uh, a trust, third-party trust could play a role in when you're trying to decide what your son or daughter's long-term living arrangements are going to be. We thought a long time, we moved into the city of Richmond to be closer to public transportation and job opportunities for a daughter. We thought for a long time we'd leave our house to the trust. But when I say our kids continue to develop at their own pace, they continue to develop at their own pace. My daughter's 27 now and can do things that I never thought she'd be able to do at 18. My wife and I were talking about, we agreed at 18, we never saw this trajectory in her life. Um, and to the point now where she's living independently. So now we're working to get that into the trust. Um, so that when we pass, she's got a place that she's living in. The trust owns it. The trust maintains it. The trustee pays the taxes. The trustee does the repairs. The trustee does all this work. Um, and then she has eligibility for benefits still, which we're still working to get in place. And there's no Medicaid estate recovery. So trusts can be very useful. Third party trust. First party trust, this is the kind of trust I typically want to avoid having to do. This is if my daughter or client were to get a direct inheritance and the money is theirs. Once it's theirs, there's Medicaid. There's certain ways we have to handle it to maintain Medicaid eligibility. And that means we have to put it into a kind of trust, a first party trust that has a Medicaid estate recovery clause to it. Do them when we have to. But then the instructions to my clients is to use that money as much as you can during their lifetime so that the state doesn't have to get repaid. Enough said on those. There are pooled special needs trusts. So this is just another way to get to the same answer as a standalone trust written by an attorney. So there's two ways to do it. You can go the pooled route, trust route, or you can go work with an attorney to create the trust agreement. There's two entities in the state of Virginia. There's Commonwealth Community Trust and the Arc of Northern Virginia. Both are nonprofits. They are excellent organizations. I talk them up with clients when it makes sense. And when I say makes sense is that they are designed first to be a little less expensive than working with an attorney. So that fits. But they're also really, really good if you have a small family and you don't have a lot of people to choose as successor trustees. Because remember, you create the trust as a parent, you manage the trust. If I were to write it, you manage it while you're living, but it doesn't get funded until after you pass. So then who takes over for you? Maybe it's another son or daughter, maybe it's an aunt or uncle, but they have to be from a younger generation. So when there's a small family and there's not a whole lot of people to choose from, the pooled trust is a great way to go. So I would encourage you to look into them. They both do real estate now. That used to be a big differentiator between the two. But yeah, they're both really good. And when I say pooled, so you create a sub account under the master trust agreement by doing the paperwork. And then all the money in the accounts is pooled together for investment purposes. It's sort of like a mutual fund almost, but um, each sub account is separate. So you're not sharing money with the other members of the pooled trust. Um, so these are excellent organizations, though. It's also good if you have a successor trustee, but you're thinking about you want to make it simple for them. Because if you do the pooled trust route, they don't have to do the taxes. They don't have to worry about whether this is a good expenditure. Commonwealth Community Trust or the Arc of Northern Virginia would say, we might want to consider doing this a different way. That's their job, right? And then the person can just be like an interface for the person with a disability. So it can be easier that way too. ABLE accounts. So no discussion on trust would be complete without a discussion about ABLE accounts. They're 529A accounts, very much like a 529B college savings fund, except ABLE accounts for persons with disability. money in an ABLE account does not count as a resource for SSI, Medicaid, Medicaid waiver eligibility. So that's why I say I personally think it's an excellent place to direct deposit your son or daughter's money when they're working, because it doesn't count as a resource anymore. You don't have to worry about the combination of their bank account and your rep payee account getting over $2,000 and forgetting about it. Social Security Administration doesn't watch that closely, but they do audit. And when they say audit, they go back like 3 years. They'll pull 2 years worth of bank statements for all the statements, and then I picture somebody with a yellow highlighter in a basement of some federal building with a swinging light bulb that just goes over the limit, over the limit, over the limit. There's nothing you can do. If you're over the $2,000 countable resource limit, they'll try to claw back the money. Not try. They will say, SSI they weren't eligible for that month, and now you owe us this. So I like ABLE accounts for direct deposit of earned income for a person receiving SSI and Medicaid. It's an okay place for parents' money. You can get a tax deduction. The money can be invested and it grows tax free. It can be used pretty much for anything that your son or daughter needs, but it does have a Medicaid estate recovery clause. Now, the state of Virginia said they're not going to do that unless federal law requires it, and federal law still requires it for persons receiving long-term care, either through a nursing home or through waiver services. So, my best guess right now, where state things are, is that, excuse me, if there's $5,000-6,000 in the account when a person passes 8,000, I don't think it's going to be worth the state's time and effort to try to get that money back. But it can have up to $100,000 in it, and not count as a resource. It can have more, but then it counts as a resource. If there's 80 to 90,000 in it, I think the state then will absolutely try to recover that money to repay it from Medicaid expenditures on the person's behalf. So I see it personally as like a super savings account for the individual's money and some parental money. Absolutely. It, One of the benefits, though, I want to talk it up more. I don't want to leave on a negative note, is that these other accounts we've been talking about, the representative payee account, trust, person can't have access to that. They're not supposed to. But an ABLE account, they can. You can get a credit card or debit card off of it. You can put some limits on it. They can have access to their own money and they can pay for things on their own. So I like ABLE accounts a lot. Just be cognizant of how much money of your own you put into it. Think of it as a savings account that you use for larger investments down the road, but use it up during their lifetime. If you're looking for an account to have a lot more money to pay for things, that's the third party trust. You keep it while you're living and you fund it after you pass. I think that's it. It is. Any other questions?
Right. I don't see any other questions in the chat, so I'll go ahead and thank everyone for attending. And thank you, Matt, for presenting. This is always a wealth of information, especially as so many of the rules have been changing annually, it seems. So keeping up with it seems to be a full-time job. Thank you so much for keeping us posted. I hope everyone will tune in for our next family education night in January. If you have any questions or if you need help registering, please feel free to reach out to me. I've dropped my contact information in the chat. And everyone, please stay safe and warm during the snowpocalypse.
Snowpocalypse.